I'm David Lombardo, and this is WCNY's The Capitol Press Room. If you ever happen to be on the end of a frivolous lawsuit in New York, which is a very litigious state, so maybe it'll happen to you, there is a pathway to have your legal bills paid by the party that brought the case. But a recent op-ed highlights the fact that state law caps the amount you can recoup, and that cap was set 4 decades ago. For more on the issue, we're joined by Dean McGee, a civil rights attorney with the libertarian-leaning Pacific Legal Foundation and author of an op-ed that highlighted the experience of a Dutchess County woman who learned the hard way the limitations of New York's cap on recouping legal fees from a frivolous lawsuit. Thanks for connecting with us on this issue, Dean. I really appreciate it.
My pleasure, Dave. Thank you.
Well, for starters, for the uninitiated, can you explain when the defendant in a lawsuit might be able to actually get the plaintiff to pay their legal bills, and what the recoupment process looks like after a plaintiff's case has been labeled as frivolous?
So the general rule in New York law is that if you're an attorney and you're engaged in frivolous conduct, you run the risk of a judge, once they've made that decision, ordering you to pay the other side's legal fees. Now, it is discretionary. The judge, it's up to the judge to decide, one, if the conduct you engaged in was frivolous, which is a very high bar, and two, if you have to pay the other side's legal fees. But it's a general understanding that that's a risk, and legal fees can run very, very high, as most people know. The twist in this case is that there's a special carve-out in New York law for personal injury cases where the attorney's fees are capped at $10,000, which this day and age, in terms of attorney's fees, is a pittance and wouldn't cover virtually any litigation costs for a case that's actually been litigated for a long time.
Well, is there any reason from your research or your experience as an attorney why it makes sense to have a special carve-out for cases that are personally injury related?
I haven't found the reason, but I'll do my best, which is the one distinction between the personal injury fee award and the general fee award. I mentioned it's generally discretionary. The statute from this 1985 law that you introduced us with says that it is mandatory in the personal injury cases for the judge to award attorney's fees. So that attorney's fee award up to $10,000 is mandatory, not discretionary, in the personal injury cases. The problem is that in 1985, maybe $10,000 did cover the average cost of attorney's fees. It no longer does. It no longer even comes close.
Yeah, the word that has a lot of meaning and oomph in that statute is shall, as opposed to may send those fees to the defendant. But I'm curious if this is the only mechanism for a defendant to recoup their legal fees. I mean, could they bring a lawsuit, for example, that is a way to get that plaintiff or that plaintiff attorney to pay what they spent if it is in excess of $10,000?
The short answer is yes. This is the only mechanism. You could, lawyers get creative. There's lawsuits called abusive process, and you can try this or that. But realistically, for the average New Yorker sued, this is the only avenue they would have. And this cap is a significant limitation on their ability to recoup anything meaningful.
Well, is there a case to be made for getting rid of the cap altogether, or should it simply just be adjusted for 2026 expenses in terms of how much someone might actually spend?
The case I'd make is get rid of it altogether, because that's the default rule, right? The default rule is you're at risk as an attorney if you bring frivolous actions of having to pay the other side's attorney's fees in full, and that can be $10,000, it can be hundreds of thousands of dollars, it can go up into the millions. But that's a very sensible check, and I say that as an attorney who brings lawsuits. It's a very sensible check on the power you wield as a lawyer to sue people, bring them into court, and have them deal with, what really can be a drawn-out nightmare. In the case of my client that I highlighted in the op-ed, 5 years of litigation and tens of thousands of dollars later, $30,000 total for her, she couldn't recoup more than 10.
Yeah, was this how you became aware of this, or was this something that you knew about during the 5-year ordeal here, and were just like, hey, we've hit that $10,000 threshold, you're going to be on the hook one way or another?
So I became aware of it only during the course of the litigation. And so this is a client who came to me when I was in private practice before I did the public interest work. And she had what was a very straightforward case from my perspective, a case of essentially mistaken identity. She'd been sued for a car accident in Queens. She had nothing to do with it. There was an error on the police report that put her as the owner of the car. It was very clearly a mistake. We had the documents to prove it. And I told her, let me talk to the plaintiff's lawyer. Let me show him these documents. He'll drop the case. And the opposite happened. He became belligerent. He accused me of being illiterate, which was fun. That was a new one for me. And he pushed this case all the way through. He, wanted us to settle, wanted us to pay up. It took 5 years for a judge to really pay attention to it, dismiss it, find it frivolous. So I learned about it through the process because typically I haven't had to deal with frivolous litigation. Most lawyers, personal injury lawyers or otherwise, are acting in good faith. He wasn't. And so this was new for me and a risk I had to lay out for the client halfway through the case.
Well, if the state does decide to just simply get rid of the cap, is there an argument to be made that we should also maybe amend that shall language and give judges more discretion? Because I don't want to besmirch attorneys, but maybe if I'm a defense attorney and I see a frivolous lawsuit coming my way, maybe we rack up those billable hours and we try to get as much money we can, knowing that ultimately it's going to come from the other side. So is there a case to be made for also giving judges in these personal injury cases even more discretion?
A case could be made for it. I think the legislature had the right idea when they made it mandatory. And that's because I think you see personal injury cases, regular people are really at risk to be targeted, small businesses or run-of-the-mill people like my client, just a Dutchess County mom caught up in this ridiculous paperwork dispute. So to add a little bit of extra risk to make plaintiffs' lawyers really think twice before not just filing, but then pursuing a case against an individual or small business, which is the common targets of these lawsuits. I think that makes sense. The fee cap has to go. Whether it's switched from mandatory to discretionary could be up to legislative judgment. I like the mandatory mechanism that the legislature put into this. I just don't like the cap.
Ultimately, who do you think is the party that should be responsible for paying legal fees if it is a frivolous lawsuit? Does it make sense to be the plaintiff attorney, or does it make more sense for it to be the plaintiff who might be the one saying, yes, keep going, don't stop with this?
Well, at the end of the day, lawyers have to exercise independent judgment. It's obviously a client-driven profession, but it's very clearly the obligation of an attorney to tell their client, no, I'm not going to pursue this because it's frivolous. So that's an independent obligation that we all have as attorneys. And so if a judge has really found that their conduct is frivolous, which again is a very high bar, I think it does make sense for lawyers to bear the risk. And again, I say that as a lawyer myself who has to be very careful about the cases I bring and or how I defend a case.
Well, a couple times now you've made a reference to that threshold for establishing a frivolous lawsuit. Is that something that also needs to be addressed as far as you're concerned?
I think the system we have works. It essentially has to be baseless either in law or in fact. Genuinely baseless. Lawyers can bring reach cases, they can bring novel theories, they can explore different factual angles of the case. In this case, I'll say the filing of the case that brought my client into this was not necessarily frivolous. This lawyer saw her name on a police report, and police reports are critical pieces of evidence. The problem is when we presented him with verified records from the DMV, verified records from the insurers, verified records down the list that you could think of, the evidence to disprove the allegation that she even owned this car or had anything to do with it, he ignored it. And the judge agreed with that. The judge said it was the continued prosecution of the case, not the filing of the case, that's frivolous.
Well, it makes you wonder, maybe somebody else was illiterate and it wasn't Dean McGee. Unfortunately, that's all the time we have for that conversation. We've been speaking with Dean McGee. He's a civil rights attorney with the Pacific Legal Foundation. Dean, thanks so much for making the time. I really appreciate it.
I'm happy to end on that note. Thanks, David.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.